don't let that happen to you. You see the guy who you have had problems with before. Maybe you had to defend yourself with a punch, kick, pepper spray, and you know that he's a danger. Don't preempt the problem.
Right. We are the Armed Attorneys. Today we're talking about what happens if lightning strikes twice. You have to defend yourself. Two separate incidents. We're not talking about multiple attackers in one incident. How does this play out legal scrutiny wise? Does this kind of past incident come up in the new incident? Maybe does it come up in court? And the last part about all this is kind of prosecutor bias and what we have seen in our practice, some things that might make you come out of this thing alive. But before we begin, show your support for the Second Amendment by hitting that like button. And I've had a handful of clients who've had to defend themselves multiple times.
I have had a handful who have had to defend themselves multiple times. And then this came up actually in my personal life this weekend. I was talking to some friends and family and talking about someone who had had a self-defense incident, and we were sort of darkly joking that, maybe you only get one, so good luck in the future. If you get attacked again, have to use your self-defense rights. So, but it brought up an interesting topic, which is lightning does and can strike twice. So what do you do, and what are the implications in court?
Yeah, well, I think we can always go back to, first off, good self-defense principles, reasonableness, immediate necessity, proportionality, using the least amount of force necessary to stop the threat. Are you being threatened with unlawful force? Well, maybe you can respond with force. Are you being threatened with unlawful deadly force? Deadly force might be appropriate. So good self-defense principles don't go out of the window. But, all right, so we got our kind of basis here. But if you find yourself in this situation, I would say there's kind of two roads we go down. Defending yourself against the same person, maybe the first time they didn't lose their life, right?
Yeah.
Think about neighbors, think about exes, those types of situations.
Yeah.
And then,
I'd actually prefer that.
well, I think that's why it has to be two different roads.
Yeah.
And then complete strangers, defensive incidents. So, what kind of comes up in your mind when you first hear this?
Yeah. So, if you have to defend yourself against the same person multiple times, actually, I don't mind that one bit. There are lots of times where I tell people, even when I know that like an incident doesn't rise to the level of it being actually charged as a crime, but if you're having a problem with someone, I'll tell people, call the police, make a record.
Yep.
Right? Good Lord. Remember I had that client up north of town who he didn't have to defend himself, but he had a really crazy neighbor. And he nearly had to defend himself. And when he called it in, he made the record, and that was great. And that really saved his bacon when he actually had to shoot and kill the guy, a couple months later.
Right.
So, that's great. Make your record.
Yeah, the downside with, and it's good, make the record. This is not saying don't make the record. The problem that a lot of these people who have repeated interactions, or they have specialized knowledge about the person they're defending themselves against, maybe it's a neighbor, maybe it's an ex, maybe it's an estranged family member. Well, guess what? That specialized knowledge is only in your head until maybe later, a detective gets the case, or the prosecutor gets the case. So the police on scene are going to be looking at that singular event to see, does this self-defense situation stand on its own 2 feet without this specialized knowledge? So just really try to work towards reasonableness, immediate necessity, and then proportionality, using the right amount of force.
Right. That is still going to be highly necessary, but your past relationship and your knowledge of that person's propensity for violence does matter. And I would say too, like, I don't know, this happens with kids a lot, right?
Okay.
So we see with kids a lot, and Richard has no idea where I'm going right now, that because like they've been bullying incidents and they know that one kid picks on them all the time, and they have a hard time separating those past incidents from what's happening in the here and now. And oftentimes they will do something physically violent without immediacy because, their brains are like 14, 15 years old.
I got jumped 2 weeks ago.
Yeah, right.
Yeah, like
They're
that's the kind of stuff they're thinking about.
Exactly. They're having a hard time separating what is true immediate necessity. Don't let that happen to you. You see the guy who you have had problems with before. Maybe you had to defend yourself with a punch, kick, pepper spray, and you know that he's a danger. Don't preempt the problem.
Right.
Don't let yourself get physically injured, but don't preempt the problem.
So the second kind of road is two separate and distinct incidents that, they're not connected whatsoever. And the thing that came to my mind is, all right, prosecutorial skepticism. I think I encounter a lot of prosecutorial skepticism, but especially with, let's say you were no billed, or let's say they never formally charged this first incident. Does this second incident kind of potentially open up a can of worms and re-investigating these things?
Oh my gosh, yes. And I mean, this is why expunctions and the like are very, very helpful when available, because, ideally you want the state to never know that you had to use self-defense in your past. But that's not always available and not always an option. And so, absolutely, once police, and because they're skeptical of self-defense in most places anyway, even in our great state of Texas, they're skeptical of self-defense. So once police and prosecutors begin to see what they interpret as either number one, a pattern, or number two, someone getting away with stuff because they feel like they're the arbiter of,
Yeah,
toe in
they're
the
Atlas
line.
holding the world up.
I know, my goodness. They're going to hyper scrutinize what you did, and perhaps even when they know they're falling on their own sword, arrest you, take you to grand jury, and push forward as far as they can, because then if you're really actually a serial killer danger, well, their hands are clean of it.
Right.
The grand jury took care of it, or your pettit jury. In the meantime, costing you tons of time, money, and stress.
Yeah, and the other thing that came up, especially, and we can go back to our two roads just a little bit, but is this previous incident admissible in the trial of the second incident? And the general rule is probably not, but there are lots of exceptions to the rules of evidence and why that might be admissible. Well, maybe first off, you want it admissible so that the jury gets to share in that specialized knowledge that you have. Maybe you accidentally, maybe you don't want them to know about it, but you open the door by saying, hey, this isn't something that I would ever do. Well, all right, you've just opened the door to this kind of stuff. You got to be really careful. Make sure you talk to your attorney about this stuff. But generally not admissible. What are some other things that you think about?
Well, there are times in which a past incident can be admissible into court, which would indicate you have a propensity to do the same thing again, but only in very specific instances, such as showing your modus operandi. And that's the one that bugs me, is let's say that, you are in a road rage incident and you get attacked and you have to, shoot through your front windshield at an attacker who's coming towards you, and everyone says, great, it's clean, it's good, you did the right thing. And then 5 years later, you get into a road rage incident and you are attacked, and you step out of your vehicle with the firearm, the person's walking towards you, and you shoot. That's close enough for a prosecutor to argue you've got an MO.
Yeah.
You've got an MO. Look, the jury's allowed to consider this. You really like to shoot people in road rage. And now that we've got two incidents, we're not so sure that you felt threatened either time.
Well, and I'll give another scenario, and this may not be as applicable because it, undermines self-defense just a little bit. But let's say the police have a cold case on their hands that happened in a very specific way, defensive incident that lines up with this very closely. Well, maybe if they wanted to reopen this cold case and say, hey, look, this is this person, no mistaken identity here because we know how these things went down, and they bring in the second incident to prove the first incident. I mean, there's a lot of exceptions to these rules, but I think it's all to say, hey, the defensive incident needs to stand on its own 2 feet.
It does. So if you have to use self-defense twice, it won't necessarily kill your self-defense the second time, but oh boy, the second time better be the cleanest act of self-defense you ever saw, because they're just going to be out to get you.
Yeah.
They're just going to be out to get you. I mean, there's nothing else to say about it.
Well, and the way that I think about it is, obviously everybody's innocent till proven guilty. These kind of multiple incidents, and you start shifting, at least in the mind of the police prosecutors, like closer towards guilty, right? Just in their minds when they're evaluating these cases. It's not a good place to be. Because I'll tell you, I mean, there's times where I don't want to say you need the prosecutor rooting for you, but you need the prosecutor believing in your theory.
Yeah, I mean, kind of though.
Yeah.
I mean, look,
You've had those grand jury cases where the prosecutor's like, it was self-defense. I can't wait to get rid of this one.
Now, of course, we are here trained to fight against the prosecutors who are actually out to get you, because
Yeah.
most of them are. But oh boy, your life gets a lot easier when they're actually in the grand jury room saying this was self-defense.
Yeah. So, I think that's all to say. Be prepared to be treated like the bad guy if you find yourself in a self-defense scenario, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please leave us a question or comment below. Until next time, we're the armed attorneys.
What are you doing?
I'm just laughing because, like, never in my life did I think I'd be like, oh, there's a sale on corn.
Yeah.
Like, so excited.
Get back on your turnip truck.